and welcome to Macros with Mythili, the ET Now show that takes a hard look at all the major macroeconomic issues and developments in India and overseas. Well, it's been 3 years since Insolvency and Bankruptcy Code (IBC) was passed by Parliament. But with each passing day, the once much-acclaimed code is becoming so convoluted and so riddled with complexities that from a time that lenders were urged to refer cases to the NCLT at practically the very first instance of default, government is now going to the other extreme and telling lenders to exercise restraint. We're certainly no closer to achieving the main objectives, speedy resolution and recycling of capital. And the government is now reportedly considering yet another round of amendments to the code, including a proposal to have a short, time-bound online bidding process to expedite resolution. Given that the last round of amendments was just less than 3 months ago, and that introduced a new time limit of 330 days, what's wrong with the code that we never seem to be able to draw a line under fresh amendments? Let me now turn to our panel of experts for answers, 2 lawyers and 1 former banker, to take stock of where IBC is headed at the moment and what can we do possibly to salvage it. So let me welcome to the show Alok Dheer, Managing Partner, Dheer & Dheer Associates, Ashish Makhija, Director, AMC Law Firm, New Delhi, and Sunil Srivastava, former DMT, State Bank of India. Welcome to the show, all 3 of you. My first question to all 3 of you in turn really is, unfortunately, the same question that I've asked all our panelists in the past, episodes on the IBC, which unfortunately has been much too often to my mind. Given the rather dismal track record, not a single case, including the first dirty dozen referred to IBC back in 2017, has been resolved in the stipulated original 270 days. Is the IBC still seen as the best mechanism for resolution of stressed assets? Let me start with you, Alok. We'll get into the details later, but for now, just a brief opening comment. Is this the best way of resolution? Alok.
Mythili, I think firstly, the IBC was the need of the hour, and I think we desperately needed a legislation to deal with insolvency in India, so it was a very welcome step. 3 years down the line, we see that there have been a lot of tailwinds, and it has not really worked out in the manner in which we wanted. There were 2 or 3 very important issues. It was supposed to be town-bound commercial decision-making, and the stakeholders, the value to the stakeholders, maximization of value to the stakeholders. The problems that we are facing is there is a lot of judicial involvement and interference in decision making, which is delaying matters. Too many changes in law. Regulations have been framed from time to time and made it very rigid, and there is a very poor infrastructure for the adjudicating authorities to deliver justice. So all of this is ending up in delaying the process, and in fact, contrary to the objectives, the maximization of the value to the shareholders, time-bound decision, judicial interventions, all of this have to a certain extent derailed the enactment. But a lot of effort is being done by all stakeholders, and I believe as more and more clarity in law emerges and the government makes the law and the regulators make it little more flexible and facility of operations of the enactment, we should be able to get a much easier way through the process.
Well, yes, I hope you're right on that, Alok, but at the moment it is a pretty damning opening statement. Ashish, would you agree with Alok? Is it, in fact, that IBC is a bit like what Churchill said of democracy, the least bad option? And does the fault for this lie with the poor drafting of the law, unrealistic expectations, and now I'm treading on pretty dangerous ground with the judiciary? Ashish?
Well, you see, when I wrote my commentary on IBC, I used to say that this is not happily worded law. But when I wrote the entire commentary, then I came to a conclusion that it is a badly drafted law. Unfortunately, if you compare even part 2 and part 3, there are a lot of differences which you will find. Whatever is mentioned in part 2, which has to be framed in rules, now it will be framed in regulations in part 3. So therefore, this is not a happy drafting. One thing I would like to comment, and I agree with Alok on a certain point, but I would say that the idea was that number one, that ease of entry should be there. That came with the reforms in 1992. But then the question was ease of exit. But here this is not made as an exit as a easy one, but I believe it has become a complicated one. But one thing is sure, under IBC, insolvency used to be a stigma. Now, of course, it will become a status symbol after this.
Okay, that's a good way of putting it. Sunil, as a banker whose hopes presumably were raised each time we thought we had the final solution to distressed assets, and there have been numerous such attempts in the past as well, is IBC no longer seen as an answer? And to take off from the question that I asked Ashish, does this vindicate the view of practitioners that whenever you draft a law, you must bring in practitioners also, so you don't have this accusation of poor drafting subsequently when we realize that, oh, we didn't take reality into account? Sunil?
So with the IBC, which was enacted in a record period of time, and it may not be perfect, but perhaps, you know, it was the need of the hour, and it just gave us a ray of hope. Because prior to that, even the liquidation proceedings, and we've seen BIFR, where it has been stretched for 20 odd years or more, and several PSUs were also there. So from that position, to get a ray of hope for exit was a great step forward.
Okay.
Now the issue is that it was revolutionary, and it is evolutionary as well. Definitely at that point of time, we expected that we would stick to that 180 plus 90-day timeline, though there would be contestations, but these would be resolved within that 270-day period. And therefore all our expectations were built on that premise. Unfortunately, there have been too many contestations, and I can't expect the lawyers to be good commercial people and commercial people to be good lawyers.
Okay.
So at some point of time, the lawyers are also discovering some aspects of the commercial part, and this is true of the entire judicial process here. So I think it's more of a cultural and procedural issue, because the same laws, and we have perhaps better laws in India compared to the US as well, but the same laws are done in a time-bound manner.
Okay, so that's a careful answer, like all bankers, I must say, Sunil. But Alok, the Supreme Court recently ruled that applications under Section 7 of the IBC are governed by Article 137 of the Limitation Act that specifies a limitation period of 3 years. What does this really mean for cases under IBC? Can you briefly explain for the benefit of our viewers, Alok?
The sum and substance of this is that the Supreme Court has now said that the date of default is the date from which you have to reckon a time period of 3 years in terms of Article 137 of the Limitation Act. The banks and financial institutions have been relying on Article 62 of the Limitation Act because that gives them 12 years of timeline from the date of default for the purpose of filing a suit in the courts. Now, invariably, the banks and financial institutions have been approaching DRT, and they obviously don't do it from the date of the first default. They try to make efforts to resolve the case, and by which time 3 years are over, because the banks and financial institutions know they have 12 years time. In cases where DRTs have been filed, and in fact even in cases where decrees have already been delivered by the courts, this particular judgment will seriously affect the banks and financial institutions from availing the remedy under the Insolvency and Bankruptcy Code, because all these cases will be thrown out on the ground of limitation. Now this, to my humble understanding, after all these are Supreme Court judgments, as a lawyer, are very narrow interpretations of the enactment, and as a commercial law, this ought to have been interpreted in a much broader sweep and for the purpose of the mischief which was supposed to be dealt with. Now, we can't have a situation where cases which are filed in DRT and decrees have been obtained are out of the process of the IBC altogether. And that has really put the cat amongst the pigeons. I think there would be great necessity for the government to involve itself and perhaps bring in an amendment to ensure that cases where decrees have been passed and where the 3-year period has elapsed from the date of default get covered under Article 62 of the Limitation Act rather than 137, so that we can implement this enactment.
Ashish, Alok raises a very relevant point, and is the part of the problem, in fact I would say a major part of the problem, is because lawyers and judiciary really don't understand commerce entirely, and they don't understand particularly the time value of money, which is why, do you think the latest amendment extending to 330 days, will that make a difference, or will we still see cases going on like SR Steel beyond 700 days? Is that the problem, because lawyers, judiciary has very little understanding of commerce? Would you think that is true?
On this aspect, you see, because ultimately the objective under IBC was a time-bound process.
Absolutely.
We had 270 days, and then of course there was a judgment by the NCLAT saying in Quinn Logistics that the time can be extended,
right.
so which is consumed during the legal process. So the time was not really the
binding,
whole thing, binding, and it was going over even 700 days in some cases. The question was that the government actually intended to do it as a time-bound process.
Sure.
But unfortunately, even if by 330 days, now let me give you an example. Supposing within 330 days I complete a CIRP process, then I move an application for approval of the resolution plan. I moved an application for approval of resolution plan in NCLT Delhi. It was filed on 2nd May 2019, and till date it has not been approved. So 330 days are over.
So what is the reason for the delay?
Well, the matters are not coming up for hearing, number one. Number two, because the courts are overburdened.
Okay.
Because the lack of infrastructure, which Alok also mentioned, I fully agree with him that there is because these courts are struggling, you see, for speed against accuracy.
Okay.
So unfortunately, and in the approval of resolution plan, a lot of objections do come. So a lot of objections are coming from every quarter, and the courts and the judiciary have to dispose of those objections. So therefore, what happens to that time limit? The court clearly says that within 14 days, the NCLT must pass an order.
Right.
That is mentioned also in section 64.
Right.
But that section 64 has been rendered nugatory by NCLAT judgment. So therefore, the judiciary says these mandatory timings are not applicable to us. You can't tell us to pass orders in time.
But if you can't have timely resolution and timely decisions from courts, then what purpose is the entire IBC code really? So Sunil, is the confusion created, thanks to the confusion really created by the NCLAT ruling in the SR Steel's case, where he said operational creditors should be put on par with financial creditors. The government is apparently now toying with the idea of coming up with a very elaborate mechanism how the proceeds should be distributed between operational creditors and financial creditors. Does this not go completely against the grain of lending, bank lending? Because the whole idea of being a secured financial creditor, and therefore you get loan at a lower rate of interest than otherwise, is because your claims presumably will rank higher. So does this not go against the very grain of lending?
Absolutely, and I will just introduce two new aspects to this. One is, as a banker, when I am looking at the creditworthiness of a borrower, the first thing I look at is how stable are his creditors. If there is a churn in the creditors, or if the creditors period is extended, or some creditors is backing out, at that moment it's a red signal for us to look at it. So which means that the operational creditors can't go on extending credit indefinitely. They are giving it for an operational cycle. That operational cycle may be 1 month, 2 months, but beyond that, the other fact is that in normal business practice, you are paid when you send the next dispatch of goods. So you don't keep on dispatching goods without being paid, unless there is a related party concept there. Now with that, the exposure of the continuity of the operational creditors for the operations of the corporate debtor is given that it's not an indefinite thing. As against that, the financial creditors, there is a time value of money, and therefore you are taking risk and over a defined period of time. So there is a difference. But going forward, when we are going to have separate classes of debt, right now we are struggling only with the first charge and the second charge and the pari passu charge, and but when you have separate classes of debt, as we have in equity, is our legal system prepared to accept that? Now that these are the commercial nuances which probably need to be harmonized with the legal system.
Absolutely. I think there's a lot that needs to be resolved as far as the IBC is concerned, but I'm afraid it's time for us to slip into a very short break. Please do stay with us. We'll be back very soon. Welcome back. You're watching Macros with Mythili, and we're discussing the latest twists and turns in the Insolvency and Bankruptcy Code and wondering when it'll all end, with a panel of experts, 2 lawyers and 1 banker. Alok, when the IBC started off, it started off with the unstated premise that all promoters are crooks, which is why we thought they could not make any bids. But now under Section 12A, promoters can return. The liquidation process allows promoters to participate in the bidding process. Is this a long overdue correction, or does it go against the very grain of what IBC was passed with in the first instance? Alok?
That's a very interesting question, Mythili. It the enactment did not start with the process that all promoters are crooks. It came somewhere down the line when Section 29A was put into the statute, and that in some sense was coming from the background that there is possibility that some of the promoters have misused the system. But the law has taken very significant turns and twists insofar as this is concerned. So once you come under the IBC, the CIRP is commenced, 29A applies, the promoters are out of bounds. Then comes 12A. If the banks and financial institutions agree to a settlement with the existing promoter, the 29A provision does not apply, so he is entitled to do. So he is not a crook, you can settle with him. If 12A does not, you are not able to resolve the matter, the CIRP process turns with him being a crook and being kept out of the system. CIRP fails, 230 of Companies Act comes in play, you are entitled to file a scheme of arrangement. Even an existing promoter is entitled, he is not a crook at that stage. Then comes, if even in the liquidation he is not able to resolve under 230, then comes the sale of assets under liquidation. He is again a crook. He is not entitled to buy them. So the judicial decision making that has taken place in terms of this, as against the policy that was put in place by the government, has shown that the entire thing is now open. There is so many stages at which he can come back into the system and he can go out. My sense is that as the point of time when 29A was come, it was not well thought out. There was a hue and cry that promoters are trying to claw back into the system. The enactment was amended, 29A came in, and there was a blanket removal of these people from the system. Thereafter, there have been series of dilution, either by judicial pronouncements or by the involvement of the promoters themselves. And we see that they are coming back into the system through various insidious ways by the way the judgments have been delivered. So we need to have a clarity. Either we need to have these persons participate in the system, or we have to weed them out entirely. So I think clarity of policy and clarity of the decision making from the judicial standpoint is very necessary for this particular aspect of the matter to take the IBC forward.
Oh, absolutely. Clarity is something we sorely require, not just in this law, but many of our laws. But Ashish, what we're saying now is that successful bidders are now seeking immunity from prosecution proceedings. We've seen in the case of JSW, where they're saying that no, the ED should not attach any of the assets of Bhushan Power and Steel. Is that correct, really? And how should we see these things? Normally, I agree, IBC ranks above everything else. But should IBC rank over and above the provisions of PMLA, which is something that has kind of been passed in the interest of ordinary taxpayers like you and I?
Well, this is again a very interesting question, which is also under the purview of the central government now. They have, in fact, you see, rope in other ministries also, the Ministry of Corporate Affairs. Now they are considering the fact that whether those previous cases can also come into play, and ED or other investigating agencies can attach. The question which you are asking is really pertains to that if it is from the criminal proceeds, right? It's the word which is used in law is proceeds of crime. Then whether the new bidder, the new resolution applicant who is paying and who is taking over, will that property will still be attached by the ED or not? The question is, we have to examine it on a very, very broader perspective. Number one, I am a resolution applicant. Right. I am bringing in 30,000 crore or say 16,000 crore, whatever the amount is. Now I am buying. Now my money probably is not from proceeds of crime. Now if I am buying it and the bankers are getting their money back, where is the loss to the bankers? Except for the fact that they are getting a haircut, which is obviously there would be there in any case where the account becomes an NPA. And in an OTS also, which they were doing, so they were also taking a haircut. Today, somebody comes in and says, I am putting in 16,000 clean money. Why you are putting me to the previous cases? So to that extent, from his perspective, it looks very good. Okay. But on the other hand, if you look at it because at the end of the day, it is a public money. Right. Now, if it's a public money which has been used which has come up from the crime, and then those attachments should be possible. So I think we need to have a balanced kind of a view.
Okay. So once again, clarity. Okay. We come back to the same position. Sunil, the cost of making you very unpopular with home buyers, and this is a view that I personally subscribe to, so I will also be as unpopular as you. Have we unnecessarily complicated the IBC by giving home buyers the status of financial creditors? Now the bankruptcy courts have been inundated with reality cases because even a single home buyer can go to court. The government is apparently now considering some kind of amendment where at least a minimum number of home buyers should be, only they should be able to raise the case to court. Have we unnecessarily complicated? Shouldn't RERA have been the right mechanism to solve the issue of home buyers?
Absolutely. You see, because if you are going to be trying to resolve a asset by involving thousands of people, it's never going to get resolved. And ultimately, the bankers also lose interest, and therefore, it's to the detriment of the home buyers who have a separate alternative through RERA. And therefore, this yesterday, I think it was mentioned that they'll probably have a class action status with a certain threshold limit. I think that is a more welcome step. But frankly,
will that help resolution in the COC? You have people with very diverse interests.
See, even in the home buyers, like for instance, the famous case in Noida, there are various home buyers who have paid only 10%, some have paid 5%, and the flats they expect to be completed, and then if you compound it with the interest that is due from them or the interest that is due from the builders, and the time to completion in each flat, the cost to completion, it is a very, very complex issue. And certainly out of the, if you have too many thousand people being represented through 10 organizations, each with its own interest, you'll never get to a resolution.
But I don't think it's possible to repeal this amendment. I think the political flack that the government will get will be too much. So then how do we move forward from here?
Maybe the best course of action is to now include them as a class action and give them a certain threshold below, at 25% or whatever. And that's, now that you have opened the can of worms, perhaps their interests need to be protected, definitely. But RERA is the proper forum for doing that.
I think we dig ourselves into a deeper and deeper hole. But Alok, in a bit to get out of all this, government has reportedly sought the Supreme Court approval to frame rules to make judges of the NCLT accountable for delays in disposing of cases. This is the first time that government is daring, in fact, to contemplate something like this. But will it stand in a court of law, Alok?
See, it's a very complex issue, and it's insofar as the judges are concerned, like every other entity within a system is accountable for what they do. Unfortunately, in our country, judicial accountability is a bad word, and ultimately the decision that will have to be taken on judicial accountability will end up at the decision making at the hands of the same judicial at the Supreme Court of India. So the judiciary has to come back and in fact create a policy for the determination whether they are accountable or not. And if the accountability of judiciary has to be decided, whatever the government may do, ultimately it is the top judicial authority in the country, the Supreme Court, which will have to have a say. But until and unless we have judicial accountability, I don't think the process of IBC for that matter, or even the other cases which are pending in courts for decades, years and years and years, will ever get resolved. And the quality of decision making of the judiciary is also something for which the judiciary should become accountable. So I am all for some form of judicial accountability. It will help the system under IBC and the entire judicial system in the country. But we have to be very careful, because the government has to, of course, make a policy, but that policy will ultimately have to be approved by the topmost judicial authority in the country. And it's a necessity, and I think it's being debated in various forums, and I'm sure over time some decision on how much accountability is there is bound to emerge.
Alok, I'm sure many of our viewers are cheering you when you say judicial accountability, because that is something that is sorely lacking in India. But Ashish, the NCLAT recently allowed the Dutch court administrator, in the case of Jet Airways, to attend the meeting of the COC. At the moment, we don't have any regulation for cross-border insolvency. So are we unnecessarily, is this NCLAT increasingly interfering, because the law as it stands does not really have scope for that? So why is the NCLAT increasingly making the job of the COC so complicated?
Well, I would say that even if we didn't have any law of cross-border insolvency in winding up provisions under the previous company law, but then there have been a lot of judicial cases which have been saying that there has to be committee of courts. Supposing some outside India, some receiver has been appointed, so he must cooperate and coordinate with the receiver in India. And here the receiver is nothing but the IRP and the RP. So I think to that extent the judgment stands, and judgment is a good judgment. But the way forward is that the government is now has to come out with the detailed cross-border insolvency provisions and the regulations. And to my understanding, I think they are bringing a new chapter in IBC now relating to cross-border insolvency only.
Okay, I don't know how much more it will complicate matters, but Sunil, given the way we've seen with IBC and now government telling bankers try and resolve it outside the IBC and NCLT, do you think bankers will do it? Because they're always worried about the CBI, CVC, ED coming down on them. So do you think they will do it, or will they still prefer to go to the NCLT route, Sunil? So and this is my last question since we're running out of time.
There are two issues which it's a transitioning that we are witnessing in this process of evolution. But once we stabilize the system of expected credit losses and start provisioning against based thereon instead of the D1, D2, D3, perhaps the bankers would have already provided for most of the assets before it reaches this precipitative stage. That being said, the other thing is to harmonize the system of lending, which the RBI had, they had under a task force, some recommendations are there for harmonizing the covenants, the documents, and the way the credit is dispensed in this country. So once there is some harmonization, then there will be a greater commonality of purpose between the lenders. Right now, even the June 7th circular requires 100% of the lenders. And some lender, we will just not sign the ICA, and therefore it doesn't go through.
Sure.
So this IBC would be the last resort. There would be a sort of the equation would always remain with the banker that they can provide for it and take it under NCLT and maybe. But then I think the objective of the entire code was to maximize the value, be fair and equitable, and time was of essence. So I agree with Mr. Dheer, though even it's a bad thing to say about a judicial, greater awareness of judicial limitations. But at the same time, at the risk of being unpopular with my co-panelists here, I think there has to be greater responsibility on the part of our lawyers as well. Because at the,
I would say greater responsibility all around, but because frankly, the kind of witch hunt that we've seen of bankers during the recent episodes of, NPAs, no banker is going to stick his neck out and take any decision. He'd much rather it goes through this convoluted process, because in the end, it's only the taxpayer who loses, not the banker. So that, I think, unfortunately, is the position now and the problems with IBC. Nobody really wants to take any decisions. Each one is saying, passing it on, passing the can down, and the law, unfortunately, is getting more and more convoluted. I do hope the government keeps all these points in mind when it comes out to the next, and I hope the last round of amendments. But thank you so much, Alok, Sunil, as well as Ashish, for joining me in the discussion and trying to make some sense of the IBC. Knowing the way the code goes, I think we'll have you back again very soon, even though I hope not. Thank you also for watching. Remember, we'll be back next week with yet another edition of Macros with Mythili. Till then, thank you and goodbye from all of us at ET Now.